Hello, this is Nevertheless, where we're going to be talking about some of what's happening in Pakistan from a slightly different perspective. Today's subject is injustice. Injustice because of the relationship between the average Pakistani and our justice system. Now, it's no secret that our justice system is one of the worst in the world. You can't enforce, or it's very difficult to enforce, a basic contract. The average case takes 25 years from institution all the way to disposal, and it's conducted in a language that the vast majority of our litigants can't understand at all. Directly linked to all of this is our criminal justice system. Our conviction rates have fallen through the floor, and as Supreme Court judge, former Supreme Court Judge Rahmat Hussain Jafri rightly said, it is usually the accused who is the favorite son of our judicial system, and the complainant is treated as a sotela. Now, we usually blame bad laws, bad systems, and bad stakeholders for our current situation, but one thing we tend to shy away from, maybe it's a bit uncomfortable to talk about, is judicial attitudes. So, in the unlikely event that the investigation does go through, that the evidence is collected adequately, that the police does not collude with the accused, and that a blood pardon doesn't spring you, usually you find that at the ultimate step, it is the decision of a superior court or a lower court which then springs the accused free despite overwhelming evidence in one direction. And we're going to take up 3 cases just for the purpose of today's Nevertheless session, which is Parveen Rehman's murder, Qandeel Baloch's honor killing, and the money laundering case relating to the current Prime Minister, Mr. Shehbaz Sharif. Now, Parveen Rehman was doing wonderful work for Karachi through the Orangi pilot project, and it was after her shocking murder that the Supreme Court had to step in, constitute GITs. Those GITs and a judicial commission were more or less uniform in their findings, that it was these 5 accused who were directly complicit in the murder. Parveen Rehman herself is on record in a television interview saying that naming names and saying who those people are. Her family to this day say that there was an entire silsila of threats that were being leveled at Parveen and at her heirs, and those only stopped when those men were put behind bars despite an initial round of complete destruction of evidence. And yet, the Sindh High Court, mostly based on procedural irregularities, decides to acquit the accused. And as we've spoken earlier, in fact, this is something that the victim's counsel, Faisal Siddiqui, also said. It seems that the judicial attitude again is premised on making the accused the favorite child of the judicial system, what to say of the victim and what to say of the fact that the victim has family members of her own. The Qandeel Baloch case is another incredibly egregious example where you had overwhelming DNA evidence, you had witness testimony, and you even had a confession by the killer, Qandeel's brother, in which he said it was for honor. The expression he used was it was because of her pictures and videos that he strangled his own sister, and this was a case where even legislative reform was already in place. That is to say, that the law had closed the loophole where if you murdered someone and it was an honor killing, you could walk if you paid blood money. Over here, you had all of these elements coming together, and you should think that the prosecution would be able to bring home Qandeel's killer's guilt. The prosecution, in fact, did succeed. He was sentenced, but again, the Lahore High Court ended up acquitting the killer on the basis that, well, it might have been that his confession was under duress, he was wearing handcuffs while he was confessing, he might not have understood the language. It threw in a quotation by Teen Vogue magazine referring to the Sharon Tate murders. Of course, the overwhelming difference between this case and that case was that Sharon Tate's murderers actually did go to jail, and the judge in this particular case was letting him walk free. The idea being that because his confession can't be taken into consideration, therefore he likely did not kill her for honor. So again, the question was not that Qandeel Baloch's brother did it. Everybody had already ascertained that he had killed his sister. The question was his motive for honor? Because it wasn't for honor, the blood pardon comes into play, and therefore he's allowed to walk. Now, away from these heinous crimes, we have white-collar crime. We have money laundering. And it does go to the heart of what our public sector is, or what service delivery should be, or what people in public life should aspire to hold themselves up to a certain standard. If the current Prime Minister has been booked in a case involving billions and billions of rupees being money laundered through accounts of low-wage employees that are actually being controlled by you, your relations, and your family companies. Now, this was a case that had been investigated by state institutions for very many years, by the FIA, and they found that there were tens of billions of rupees being rolled into these accounts between the years of 2008 and 2018. Now, again, despite overwhelming evidence, despite an entire money trail, despite actual TTs, despite the fact that, well, if you look at the Panama JIT and you look at certain confessions that have never been retracted before any court or any forum, regardless of aspersions cast on it, it has been an alleged modus operandi of the Sharif family to be money laundering or being complicit in the commission of money laundering, at least since the year 2000, and before that, the late 90s, leading up to the investigations of 2000. But in the judgment that acquits Mr. Sharif, we see that the judge actually waves a magic wand, using only procedural defects, using only legal technicalities, and again the core question as to why billions of rupees were being parked in the accounts of employees that had no means of income to justify such massive transactions. That question, as always, remained unanswered, and the judgment actually went some distance further and said that there was no need for further investigation. So what is common to these three very disparate cases? The fact that somehow the investigation, despite being compromised initially in Parveen Rehman's case in particular, somehow the investigation worked. There was evidence collection, there was there was overwhelming evidence in one direction, and yet right at the end you found that there was a judicial attitude that consistently tried to ensure that the accused would walk, even though you saw that not even the slightest doubt was there in their defense. So there needs to be a repositioning of judicial attitudes overall, and perhaps we could do well to remember what Matthew Hale, a very old-time English judge, once said, despite being no fan of what the influence of the English judicial system did to ours, but he said that in crimes of blood, there has to be severity in justice. But forget crimes of blood, forget crimes, in fact, of any nature. It is at the ultimate stage, at the level of the Supreme Court, at the level of the High Court, and what we are now seeing increasingly in the courts of first instance, it is the accused that is meant to walk, and it is as if the complainant or the victim or the family of the victim don't factor in at all. So after a certain point, we need to also pass through those cases where even if the evidence does work out, even if the prosecution does work out, our judges need to have slightly more compassion for the victim rather than the murderer or the white-collar criminal. That's nevertheless for today. We'll see you again very soon.